Good evening. On behalf of the League of Women Voters, Leelanau County, I welcome you to tonight's forum entitled Immigration 101, How It Works and How It Doesn't, a community conversation. My name is Christy Bardenhagen, and I am past president of the League. Members of the Farm Labor Task Force who planned this forum, and I would like them to stand when I call their names, are Marian Krumkowski, I think she's outside, Suzanne Hoff, Sam Getzinger,
Just stand.
Susan Lombardi, Barbara Krause,
Stand up.
and Nancy Lindeman.
And yourself. And you.
Oh, and me. The League of Women Voters is a nonpartisan political organization that does three things. We encourage informed and active participation in government. We work to increase understanding of major public policy issues. And we also strive to influence public policy through education and advocacy. We never ever support or oppose candidates or parties. Men and women who are 16 years of age and American citizens may join the League. The Leelanau League currently has 180 members, of which 35% are men. More information on the League may be found at our website, which is lwvleelanau.org. Dues are $60 a year for an individual or $90 for a family membership. Membership applications can be found online at our website and also on the table in the hallway. We want to thank the Leelanau Peninsula Economic Foundation for their support for tonight's forum, as well as those area organizations who have expressed appreciation for a program on immigration and the law. Before we begin, I invite you to attend the last forum of our 2017-2018 season, entitled Care for the Planet, Because Your Health Depends on It. We will feature 3 panelists who will speak on health impacts of climate change and what we can do about them. This forum will take place a week from tomorrow, Wednesday, June 6th, at noon here in this room. We hope you can come. Now I would like to introduce Suzanne Hoff, our moderator. Suzanne?
Thank you.
Thank you and welcome to our program this evening. We're going to jump right in. More seats are available in the back. Thank you for helping set up, Jeff. Okay, let's start off. Despite its long history of immigration, the United States has oscillated between perceiving immigration as a valuable resource and as a major challenge. When you read the chronological handout on foreign workers, you will see that the U.S. has a long history of securing workers through legal or other means, then expelling foreign workers when they are no longer needed. In our 5-county area, we primarily see migrant or seasonal agricultural workers and their families whose home countries are Mexico or Central America. Most have legal status, some are unauthorized, or their legal documents have expired. Legal status for unauthorized residents is a hotly argued issue and the source of anxiety among our residents, legal or not. For that reason, we want to look beyond the sound bites we often hear when opinions on immigration are expressed. We titled it Immigration 101 because many of us are unclear about current immigration law, how it is applied, and when or if local law enforcement is engaged. A conversation means that this program is not a debate between our panelists or them with you. Our panelists are here to inform. Ask your questions after our panelists speak during Q&A, or tell us of your personal experience with current immigration law. A microphone will be brought to you during the Q&A portion of the program, And I will make a note here before I introduce our panelists that we did contact Valentina Seeley. She is a U.S. Immigration and Customs Enforcement Community Relations Officer out of Detroit. She was very interested in our program. We've talked to her a number of times over the past years to invite her to do a program with us. But she ultimately declined due to videotaping and media coverage of this event. Now we're going to hold a second community conversation this fall on immigration reform. Tonight is the way things are now, and we have 4 proposals at this time in our current Congress, reform bills on immigration. One you can look up that I found quite quickly is House Resolution 4760, Securing America's Future Act of 2018, and it has a fairly robust section on new immigration law for workers. But we will let you know about that. This moves along fairly quickly once our government really sets their mind to it. So we may have this program on immigration reform sooner than this autumn. Well, let's begin, and we'll welcome our panelists for today's program. Marcelo Betti is to my right. He's an associate attorney at the law firm of Rosie and Gardner PC, and practices immigration law in Traverse City. He is also a part-time staff attorney for Justice for Our Neighbors, a statewide nonprofit organization and ministry of the Central Methodist Church. JFON provides immigration legal services to low-income individuals. Marcelo is originally from Sao Paulo, Brazil, and he first came to Northern Michigan as an exchange student in 2000. He now lives in Traverse City with his wife and their son, Lorenzo. Andy Fleece is to his right, and Andy worked agricultural jobs throughout his teens in his home area of Muskegon, and after obtaining his BA in horticulture from MSU, Andy worked sherries at the Mission Peninsula Krupa farm. I believe here in our peninsula we say Krupa, but Krupa farm, and grapes at the Krupa-owned Old Mission Peninsula Cellars. For the past 5 years, Andy has been the vineyard manager for Shady Lane Cellars and knows firsthand the challenges faced by agricultural employers in finding skilled workers, as well as the challenges faced by those workers living in our community. And to my far right, Marshall Collins Jr. Was born and raised in Northport. He's a graduate of Concordia College, and he is currently the Instructional Services Specialist for School Health at Traverse Bay Area Intermediate School District and soccer coach with Traverse Bay Athletic Youth Soccer. Got that right? Good, thank you. Marshall co-chairs with Traverse City Chief of Police Jeff O'Brien the Northwest Michigan chapter of Advocates and Leaders for Police and Community Trust. Established locally in 2016, AllPact is one of the 10 chapters in Michigan begun in 2010. I have a little synopsis of AllPact, but Marshall, are you going to tell us what the organization is and how it started when you come up?
Sure.
Okay.
I can do that for you.
Thank you. Well, let's begin. Marcelo Betti, please, if you would bring us up to date on immigration law and its current practice here.
Let's see if this works. Can anyone hear me? Yeah. Oh, good. Okay. Good evening, everyone. Again, my name is Marcelo Betti, and I was invited to speak here tonight to provide some information about what immigration looks like in the United States in 2018, and with a focus on how difficult it is for certain immigrants to obtain lawful status. There's not a lot of time for me to do this, but my goal is basically to provide you with enough background information to understand how complex of an issue immigration really is. Not only to individuals who live and work here in our region, but also to the federal government, which is tasked with enforcing the laws that we have. Now, I usually open my presentations with a tearjerker type of story about clients I've worked with in the past to hook everyone in, but tonight I'm going to go straight to the nitty-gritty of the law, so I hope that's okay. All right, now perhaps you already know that immigration law is a matter of federal law. It all starts with the US Constitution. And there are only two specific references to immigration in the Constitution. Article 1, Section 8 authorizes Congress to establish a uniform rule of naturalization. And then the second reference is in the 14th Amendment, which states that all persons born or naturalized in the United States are citizens of the United States. That's the birthright citizenship clause. Now, over the years, Congress has used its powers to enact laws regarding immigration, and the controlling law in effect right now is the Immigration and Nationality Act, or INA. And the INA is a very complex statute. It's basically a patchwork of bills that have been passed over the last 50 years or so. And frankly, I have a hard time believing that there's any lawmaker in DC who knows it inside out. Now, before I tell you what the INA does, let me first point out a curious detail, an important detail about it. The INA is primarily a civil and not a criminal statute, not a penal statute. In other words, most immigration violations, overstaying a visa, working under the table without authorization, being unlawfully present in the United States, those are not considered crimes under US law. Instead, they're technically civil infractions. They're like a traffic ticket, but with much more serious consequences. And I'll get back to this point in a bit. That said, there are a few criminal provisions in the INA. For example, if a person lies to an immigration officer or otherwise commits fraud or enters the US without permission, they could technically be prosecuted for that. So how do you know what's a crime and what is not a crime? Well, all you can really do is read the statute, which is really boring and I do not recommend. Anyway, the INA does primarily three things. The first thing is it lists specific categories of people who may enter the United States based on various criteria: country of origin, relationship to a US petitioner, etc., etc. Now, perhaps you never thought about it because you are a US citizen and you correctly assume that with very few exceptions, your US passport allows you to travel to almost any country in the world. But if you're a citizen of a developing country, you probably know that not all passports are created equal. Not everyone who wants to visit the US is allowed to do so. To come here, a foreign citizen must usually obtain a visa that is tailored for the intended purpose of that person's trip, even if they only intend to be here temporarily. For example, if a Brazilian family wants to come to the US and visit Disneyland, then they must first apply and obtain a B2 visitor visa for pleasure from a US consulate abroad. If a Japanese student is accepted into Harvard, then they must obtain a specific student visa to come here and study. If a German basketball player wants to come here and play professionally, then he must first obtain a specific work visa for professional athletes, and on and on and on. So basically, if the intended purpose of your trip doesn't fit into one of the specific categories listed in the law, then you cannot come to the US, not even for a quick visit. And because US immigration authorities have a lot of discretion in the issuance of visas, just because you qualify for a visa, it doesn't necessarily mean that you're going to get one. No foreign citizen has an ingrained right to a US visa. Now, the same concept applies for foreign persons who wish to immigrate to the US permanently. The INA lists specific categories of people who may apply to become lawful permanent residents, that is, to live and work in the US indefinitely, under what is commonly known as the green card. Some of the categories are based on the foreign citizen having a qualifying family relationship to a U.S. citizen or resident. For example, they're married to a U.S. citizen, they have a parent or a child who's a U.S. citizen or a sibling. Other categories are based on having, for example, an employment offer to come work here in the United States. In other words, there are some circumstances when, if you are a U.S. employer, you can sponsor a foreign worker to come here and work for you, in some circumstances. This is where I go on my quick tangent number 1, okay, about the plight of U.S. farmers. And I'm sure Andy will be able to follow up with much more information on that. Now, for better or worse, most employment-based immigration options are reserved for highly specialized or highly qualified labor. We're talking doctors, software engineers, and other occupations that usually require the foreign worker to have undergone formal training or education in order to perform that task. Now, in the opinion of the US government, most farm workers do not fit that description. As a result, it's usually unfeasible for a US farmer to sponsor a worker for a green card, because the farmer would have to spend thousands of dollars trying to prove to the US government that there are no similarly qualified workers available in the US. And that's a process that could take 1 to 3 years. Our growing season is not that long. So, now, US farmers can also try to get visas for temporary or seasonal workers. But that process also comes with several challenges. Even when you get beyond the red tape and the sheer cost of each worker's immigration papers, there's an issue of timing. The US farmer can only start the paperwork to bring a temporary worker here within a limited number of days before the work is set to start. You can't just file papers one summer for workers to come here the following spring, okay? And then once the paperwork is filed with immigration, the farmer is at the mercy of the US government to timely process that paperwork. And then the problem is that when you're a farmer, especially in Michigan, is that you're also dealing with another, even more powerful force than the US government, and that's our weather. If spring comes early one year, you may not have the workers that you petitioned for because the government is still processing their paperwork. And if spring comes late, then you'll be stuck here with foreign workers whom you must pay, otherwise you're going to get in trouble for labor and immigration violations. And then there's a clincher, which is the reality that a lot of farmers have had the same workers come and help out of their farm for years or even decades. But if the foreign worker is in the US unlawfully, either because they overstayed a visa or because they entered without permission, then that worker is not going to be eligible for any work visa. Nothing. There is literally no option to fix their status through an employment offer. In short, the laws and regulations that are currently in place do not work as intended, especially when we're dealing with agricultural labor. The law helps neither the farmer nor the worker. Which brings me to my second point about the INA. The INA sets visa quotas. In other words, how many of each category of immigrant can enter over the course of a 1-year period. Now, the consequence of a quota system is pretty obvious. For some visas, there are going to be very long waits. Let me give you a dramatic example. If you are a US citizen and you have a brother from the Philippines, you can file an immigrant petition on your brother's behalf. The problem is that USCIS, US Citizenship and Immigration Services, the agency that processes these papers, they're currently adjudicating petitions under that category that were filed in February of 1995. That's a 23-year wait. Now, a similar problem arises if you are a US employer who wishes to sponsor an unskilled worker. It's not as dramatic, but even if you're willing to invest thousands of dollars and lots of time on that process, you are also going to be at the mercy of the quota system, which only allots 10,000 green cards per year to unskilled workers. Now, maybe 10,000 sounds like a lot to you, but you got to bear in mind that each year, the U.S. issues approximately 1 million green cards, and 10,000 is only 1% of that. Anyway, here's the third thing that the INA does. It sets forth a list of reasons why a person may be deported from or barred from entering the United States. The situation that I see most often in my work, and I'll discuss that in a little more detail in a bit, is that an individual who has been physically present in the United States without permission for 1 year or more is generally barred from obtaining any immigration benefit, even if they fit into one of those categories that are set forth in the law. For example, even if they're married to a U.S. citizen, they cannot apply for a green card here in the U.S. So those 3 points I enumerated are crucial for understanding our immigration system, because here's what they amount to, as you've probably noticed by now. Not everyone who wishes to immigrate to the U.S. or wishes to fix their immigration status has a legal avenue to do so. So that was the easy part of my presentation. Now let's look at some numbers, some census data. How about that pollen? Just everywhere, including my lungs. Now, as of 2014, according to most recent census data that I could dig up, the U.S. immigrant population stood at more than 42 million individuals, or 13.3% of the total U.S. population of 319 million. So to compare, between 1860 and 1920, the immigrant share of the U.S. population fluctuated between 13 and 15%. So the current numbers are consistent with other times in our history, percentage-wise. When we speak about these 42 million individuals, we're talking about the share of the U.S. population who was born abroad, regardless of their current immigration status. For example, that 42 million chunk includes people who immigrated to the United States and became naturalized citizens, which is the category that I fall under. I came here from Brazil, but over the years and a lot of paperwork, I became a U.S. citizen. But I'm still an immigrant. I went through that process and I was born abroad. That 42 million also includes people who are currently lawful permanent residents of the United States. That is, they have green cards. A common misunderstanding is that getting a green card is the exact same thing as becoming a U.S. citizen. And that's not correct. In fact, it's a big pet peeve of mine. Generally speaking, a foreign individual cannot even apply to become a U.S. citizen without first being a green card holder for several years. You literally have to do your time. A lawful permanent resident can live and work here in the U.S. indefinitely, but they don't have all the rights of a U.S. citizen. They cannot vote or serve in a jury. They may be disqualified or not eligible to various government jobs. And if they behave badly, they may be deported from the United States, even if they're married to a U.S. citizen and have U.S. citizen children. You might find interesting to know that a green card holder is not required to ever become a U.S. citizen. They can just keep renewing their green card indefinitely. You may also be surprised to know that a green card holder does not lose their immigration status, generally, if their green card expires. There's a narrow circumstance in which that could happen, but I'm not going to get into that here. But generally speaking, if you're a green card holder, a lawful permanent resident, your green card expires, you continue to be a lawful permanent resident. The fact that they don't have a valid document to prove that doesn't change their status. So, if an expired green card holder is not out of status, what exactly does it mean to be out of status? Who is it who doesn't have status? So let's look at our census data again. We know that there are approximately 42 million foreign-born individuals. That includes naturalized citizens. That includes green card holders, regardless of whether their card has expired or not. But that 42 million also includes people who are sometimes referred to as illegal immigrants. Another word for that demographic are the undocumented, meaning individuals who are foreign citizens and who are presently in the U.S. without lawful immigration status. And here's the thing, just to make things more complicated. Within the undocumented, there are two very distinct groups. You have persons who enter the country illegally, without inspection by an immigration officer, and then you have people who enter the country with authorization, for example, with a visa, and then they overstayed their welcome, and they're now here without authorization. This distinction is very, very, very important for the reason that, well, I guess I didn't specify it, but I mentioned it a few moments ago. Unlawful presence in the United States is not a crime. Unlawful entry into the United States is a crime, but unlawful presence, like overstaying a visa, is not. Now, the legal implications of that distinction are huge, but they boil down to this. A person who entered the United States with permission generally will have more options to fix their immigration status than a person who entered without permission. Indeed, a person who entered the country without permission is generally out of luck. In most cases, that person is barred from applying for any immigration status, even if that person has been in the U.S. for decades, even if that person is married to a U.S. citizen and therefore fits into a category listed in our laws, and even if their unlawful entry into the U.S. happened when that person was a young child. Which brings me to my tangent number 2, because what I just described is precisely the issue with most dreamers, the individuals who entered or remained in the country without permission when they were young children. Most of them came to the U.S. with their families. They were enrolled in and they attended U.S. schools. Many of them don't even remember what it's like in the country they were born. But if they entered the United States without inspection, even if a dreamer marries a U.S. citizen, has U.S. citizen children, goes to college here, gets a PhD, it usually doesn't matter. They cannot apply for a green card to stay here in the United States. Instead, they would have to leave the U.S. and apply for an immigrant visa at the U.S. consulate in their country of origin. And then there's a cruel, cruel twist. Because this hypothetical dreamer has spent more than 1 year unlawfully present in the United States, by definition, because they enter here as a kid, the moment that he or she sets foot outside of the United States, they will be barred from returning to the U.S. for a period of 10 years. And why? Because that's what the law says. That's what the INA says. So that's rough. Now, there are some cases where it's possible to obtain a waiver of that 10-year bar, but those are very, very difficult cases. Essentially, to get a waiver, you have to prove that the U.S. citizen spouse or parent, but let's use spouse in this example, would suffer extreme hardship if the foreign spouse was barred from re-entering the country after 10 years, or for 10 years. Now that sounds like an easy thing to prove. Keeping a married couple separated for 10 years sounds like extreme hardship to me. But that's not the government's position. Instead, they say that such a long period of separation